Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Hey, good morning, everyone. Today's Tuesday, and here we are again on the Bottled Business Sense Show. I want to welcome all of our regular viewers, and if you are new, welcome to the Bottled Business Sense Show. I am Rick Moscoso, one of your co-hosts today. We have Bill Bernard on the other side, but before we get to him, I just wanted to remind everyone that you can always watch our episodes on Facebook, YouTube, LinkedIn, Twitter, and listen in on iTunes. So if you would, hop over to iTunes, download, like, review, and all that stuff on there, that would be great. And tune into our iTunes channel. So that being said, I want to welcome everyone again. And today, Bill is going to speak on a subject centered around estate planning. So before that, let's just welcome in Bill.
Hey, Rick, how are you? How is everybody out there? Yeah, we're going to talk about revisiting your estate plan, essentially, because this is important stuff that a lot of people forget about. Before we do that, I wanted to kind of take a hitch on what Rick just said and kind of remind everybody that we are on iTunes, as Rick said. You go to iTunes, you go to podcast, you search for Bottled Business Sense Show. You can subscribe to us, you can rate us, you can review us. We'd love to have you do that. And download as many episodes as you want. So hopefully that'll be a convenience that you can take advantage of. So anyway, today we're going to talk about estate planning again. And Rick, what did I don't have it in front of me. What did I name the show again today? What was the show called?
Avoiding the crisis of an outdated estate plan.
There you go. Okay. So clients say all the time that they're unsurprised to find out that people that have trust that they're aware of and that have close family ties within that family end up in trust litigation with siblings, cousins, or other people that are within the family. And yet other clients say, hey, I know people who have a trust and they never saw it coming. Bingo. When they passed away, there was all this litigation. There was all this fuss and muss. And so I thought I'd go over in a very quick show today about 4 or 5 things that actually about probably 5, 6, or 7 things that might be something you want to take a look at in order to avoid any kind of problems once you pass. Now, you can take 2 attitudes to this. You can say, well, once I pass, hey, look, I went to the trouble of getting a trust to avoid probate for my family. That's it. I'm signing out. I've done enough. Or you can walk the extra mile and say, hey, I want to make sure, because I went through all of this stuff, to make sure I got this trust done and this estate done correctly, I want to make sure that it functions properly and the way it was meant to function once I'm gone. And now we all know that the trust is supposed to function in a particular way, and that if the trustee is supposed to make sure that happens. That's why you pick a trustee that you can trust. But you can't control what other people may try to do to contest the trust, even though there's going to more than likely be a no contest clause in there, meaning if they contest the trust and they don't have probable cause enough to do that and they lose, then they're going to end up getting nothing. That may not be enough of a deterrent for some people, let's face it. So where you have a trust that you have unequal distribution to children, you may want to talk to the children about it, because remember, beneficiaries who are beneficiaries while you're still alive don't have a right to know the substance of the trust. But you could always volunteer and talk to them and tell them what's in it. And what you may want to do is explain to them what you're leaving, to whom you're leaving it, and why you're leaving it. And this way, it can be memorialized by you in a writing, or you can get the beneficiaries to acknowledge in a writing, in a contract of sorts, that, hey, they've been explained the trust proceeds and how the trust is going to be distributed once my parents or whoever it may be is gone. And that's going to provide the court, should the trust ever be contested, a real good roadmap to be able to say, hey, listen, you signed this, you didn't contest it when it was explained to you. We also have something from your parents where they indicated they explained it to you. Those two things meld together, and now you've taken all the precautions really that you need to take, and you can maybe avoid a conflict down the road. And I might add that don't think that because you have children who always get along, that's not going to be a problem. Money does funny things to people, and sometimes you least expect what's going to happen as you're watching up there from the heavens as to what's going on after you pass. But remember also, unexpected events can occur. Somebody has a blowout in their relationship. They don't get along anymore. They're angry, or they have a disagreement with you while you're still alive. That changes their whole attitude. You never know how people are going to react. So that's one thing you might be able to do. Also, let me mention the fact that perhaps it is a loan with respect to which the child signed a promissory note, but the child stopped making monthly payments. Maybe the parent allowed the child to reside rent-free in a property that they owned over the course of so many years. The parent promised a family business to a child who ran it for many years but didn't clearly document the transition or the transactions. I'm sorry. So these are things that can pop up, and it's another reason why you may even have more of an incentive to sit down and discuss these loose ends with kids who are beneficiaries, and maybe even get something in writing, again, that would supplement your intent with regard to the trust. Now, this also allows you to update your trust. When you're doing this review, there may be new things that you want to tackle in your trust. There may be new tax issues you want to go over. There may be there may be someone who needs more help because of a disability, and you'll want to change your trust and make allowance for that. There may be new property that you want to add to your trust. You may want to amend it in some way. So these are things that you really should be aware of as you go through life, obviously, prior to the time you pass, and make sure that your estate is intact. So the estate planning just doesn't stop with the preparation of the trust and the attendant trust documents. Let's talk a little bit about allocation of assets. Assets might be sold so there is only cash to divide, and then therefore it's distributed on a pro rata basis. So if you have a situation where you have properties and you want certain beneficiaries to have certain properties, then this would be a good time to go over it with them and get them to sign a document to that effect, as in terms of that being their understanding once you explain it to them. But an easier way might be to instruct the trustee in the trust to sell the assets, the successor trustee who takes over when you pass, sell the assets, whatever there may be, and then distribute the liquid assets on a pro rata basis or on an equal basis. Again, with explanations to your beneficiaries if you want to go that extra route. But certainly, even if you don't go that extra route, to ensure in the trust that all of the assets must be sold and then distributed alleviates the issue of people arguing over which property who wants to get, if indeed you haven't spelled out which property which beneficiary should get, should you have multiple properties, for example. You can instruct the trustee to sell those properties and allocate the distribution of the liquid assets in the manner that you see fit. Another important issue when you review trust, the state of your estate plan, let's put it that way, which would have been a good name for the show, by the way, the state of your estate plan. What did you think of that, Rick? I should have named it that, huh? Anyway, let's talk a little bit about blended families. Mom or dad may want to provide for a second or third or fourth spouse, or children who were from a first marriage but not of the current marriage. These are situations that need to be discussed and sorted out. And while you can memorialize those intentions within the trust, you're going to want to make sure that you sit down and explain, at least I would, explain to the beneficiaries what the situation is, why you want to do it. And again, if you sense the least bit of discontent, have a little contract drawn up, have them sign it. This is my understanding. It was explained to me on such and such a date. I acknowledge and agree that the trustor's intentions will be followed at the time of the trustor's passing. The trustor, of course, being the creator of the trust, being you, the person who created the trust. What about a failure to follow the trust terms? Many marital trusts, for example, require the surviving spouse to take certain actions following the death of the first spouse, such as funding a subtrust with a deceased spouse's share of the assets. This can be important because there's ways to do this where you get a stepped-up basis in the value of the property. So when that property is eventually sold, when that property is eventually passed on upon the death of the second spouse, the beneficiary gets a stepped-up basis and won't have as much taxes to be involved with, because the property is now going to be worth more than what it was when the person who created the trust first purchased the property. So these are important issues to go over to make sure that the trust terms are followed, and that the trustee understands that there's a subtrust here, for example, that's been created. Maybe there hasn't been one created, and then you now want to do this. Maybe you've come into possession of additional properties, things that may have changed to where you now want to create a subtrust where you didn't have one before. So you need to be aware of these things so you can go to the proper professional and seek guidance about what to do in what specific situation as it applies to your particular estate. What if you have a successor trustee who is unable or unwilling to act properly? They may lack the time to focus on the administration of the trust or the impartiality to be fair to all beneficiaries, and they may refrain from seeking legal accounting and guidance that they need. So here's two things you can do if you're worried about situations like that. Number one, you can appoint a trust protector in your trust, somebody who's a professional who steps in and says, wait a minute, things aren't going the way they're supposed to. I've been granted the power to make certain decisions. I'm gonna make those decisions. And if I have to, I can appoint a new trustee who will abide by the trust terms and carry out the wishes of the creators of the trust. The second thing is you can select as a trustee, a successor trustee initially, whether or not you have a trust protector, a fiduciary like a bank or some sort of insurance company. that has no skin in the game, that can be very objective when it carries out the terms of the trust and ensures that the beneficiaries are treated equally and fairly according to the terms of the trust. Remember, what beneficiaries may think is fair or equal may not be what the creators of the trust feel is fair and equal, and therefore it's the creators of the trust whose wishes have to be carried out, and a professional has no concern for the beneficiaries other than making sure the beneficiaries get what they're supposed to get according to the terms of the trust. And finally, here's an issue that came up with a number of my clients, even though I advised against it. What happens when you have co-trustees? Many times when you have co-trustees, co-successor trustees, so mom and dad create a trust. There's two brothers, for example, they're made co-trustees, meaning that they have to agree on whatever decisions are made in the administration of the estate. You want to be able to revisit this and be able to decide whether they're going to be able to cooperate. And really, I think you should come to the conclusion that one person or one business entity, like a bank or an insurance company, might be more appropriate, because that way the decision could be made quick and final. Excuse me. You may want to also think about a trust protector in this situation. If you do have co-trustees and the co-trustees can't agree, the trust protector can be granted the power to be able to say, okay, if you don't agree, then I'm coming in and I'm going to make this objective decision. And what you guys may have wanted is not going to happen because the trust protector is going to make the decision. So be aware of that as an additional way to avoid any disputes if you have co-trustees and you don't want to take both of them out of the mix and appoint only one successor trustee. So remember, by proactively surveying and addressing these risks, you can avoid conflicts and make sure your plans aren't undermined once you've passed. So think about these things, see your professional, make sure that you have your estate plan updated in the manner that you really want. And remember, there is always a way to provide in your trust with various provisions that say, hey, we want a fiduciary other than just a successor trustee. We want a CPA to come in and take a look at the trust. We want an attorney to step in as a trust protector, or a CPA. Anybody can be a trust protector. Somebody who can make sure that where I have some feelings of discontent surrounding what the beneficiaries may or may not do when I'm gone, I can ensure that my trust terms and my intent will be carried out in the manner that I desire. So I hope that's been helpful. And if you have any questions, please address them to Rick, since I think he might have fallen asleep in the show there earlier.
No, I was here. I just couldn't find the right button.
you can address him to Rick, and Rick will get to me, and or we can go tell them about. I think they may already know, Rick. There's a place on our YouTube channel, right? Or is in the place?
Well, they can comment. Sure, they can comment here in the comment feed at any time, and we'll pick that up. Or if you want to send something directly, go ahead and just email bottledbusinessshow@gmail.com, and we'll get that over to Bill as well. Bill, let me ask you a question regarding the trust protector. I know every situation is a little bit different, and typically the trust protector is that. Do you recommend an individual or an entity, or how do you go about determining which is best?
It just there really is no which is best. It really is your personal preference. For example, if you have an attorney or a CPA versus a bank or a insurance company, you have to presume that all four of those. Two of those, the bank and the insurance company, are going to be totally objective because they have no skin in the game. If you have an attorney or a CPA, for example, they may know the clients from having dealt with the clients who are the creators of the trust who are now passed. And of course, that's good because they're going to want to make sure, because their loyalty is to the creators of the trust, they're going to want to make sure that the intent of the trust is carried out. So either way you look at it, you've got the intent of the trust being primary and the beneficiary's desires being secondary in either of those two scenarios. And remember, the beneficiary's desires don't mean a thing to me when I create a trust. I don't care anything about them other than I want to make sure that they're included in the trust according to the way my clients want them in there. But I don't have any desire, nor should any attorney in the creating a trust have any desire for what the beneficiaries may or may not want, because your client are the trustors of the trust, the creators of the trust, and that's whose intent you're setting up the estate plan for.
Right. And how often do you recommend, or do you do it for your clients? How often do you update or review their trusts with them?
Well, remember, you can only update an estate plan if the client approaches you. And a lot of clients have bad track records in doing that. They, heck, some clients wait months before they even decide they want their trusts sent to them and executed and dated. But you remember, you can't work with information you don't have. So unless a client approaches you and tells you they want to update their estate plan, you're you-know-what out of luck. Now, you can certainly have a system where you have letters going out to clients every 3 years maybe and say, hey, it's time to just take a look at your estate plan. You can meet with me or you can give me a call. There's no charge for doing that. Go ahead and let's discuss any potential updates. But again, the actual updates themselves are dependent upon the information you receive, and you can only receive that information if the client indeed calls you back and responds to your letter. So that's the way I would typically do it. Send out some correspondence, have it diaried based on when the trust is created. Just send it out to them. Include in there that there's no charge so they don't get the impression that there's something dramatically wrong and that they need to call you. You basically say, there's a certain amount of time has passed, and it's always good to update your estate plan. And you may even cite a couple of the examples that I went over today to make sure that they're aware of what problems could arise based on what their particular situation might be. So,
yeah. So really, the primary onus is on the trust owner to.
Oh yeah, sure. The trust owner has to communicate with you, but that's not to say again that you can't attempt to generate that communication by sending out correspondence or having your secretary give them a call or whatever. But again, either way, whether they volunteer or whether they respond to your initiated correspondence or a phone call, yeah, they're going to have to respond because they have the golden egg. They have the information that you don't yet have, if there is information that needs to be updated in the trust.
Right.
So yeah, it's a constant game that you need to play. There's no real winner or loser. You've got to consistently keep on the field and run with the ball, so to speak, and make sure that people are aware that things may change in their life, but they may not be aware that those changes require an updated estate plan. It's only when you become aware of those changes that you can say, hey, wait a minute, this needs to be changed in your estate, and we need to take care of that.
Right, right.
So
well,
that's it.
Yeah, that's awesome. Let's, before we close out the show, I want you to take this opportunity because you and I worked together putting this together. Well, I helped build it, but you really put the heart and soul and the meat into it because this is your baby. But I think this would be a great opportunity to just plug PYE 365 a little bit. Oh, well, thanks.
Well, PYE 365 is a website that I've set up that stands for Protect Your Estate 365, 365 days of the year. It has two URLs, PYE365.com and ProtectYourEstate365.com. It takes you to the same website. And it's essentially a website that provides a very, 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 very economical price for what I term as a trust package. It sets up your entire living trust, which typically runs anywhere between 30 to 35 pages if you do the trust properly. It includes your pour-over wills. It includes your powers of attorney for healthcare, your power of attorney for assets, living will, burial instructions, even a deed for one of your homes, your central primary residence, that's prepared for you to take down and file with the county recorder's office to transfer your property into the trust. So all of this is there, but even more importantly are drop-down boxes and videos, depending on which you like best, where you can go and get answers to some of the primary questions that most people have concerns about when they want to plan an estate. So the combination, I feel the unique combination of education in a very succinct format and a very, very economical price, a price that's so economical that I've actually had other attorneys complain to me about undercutting the market at times, believe it or not. And those were some years back, but nevertheless, I'm in a position where I don't need to make top dollar, but rather want to provide quality work to middle-income families, especially, and also in particular as a result of COVID, the onset of COVID. So it's a place where you can go and get educated and feel comfortable in spending money that is going to be well worth your while to set up an estate plan and avoid the nightmare and costs and heartaches for your family of probate court. So that's it in a nutshell.
Yeah, that's awesome. I know the main difference too, as I was helping you put this together, is that, you can find a lot of resources online and DIY type of things, but you get Bill's vast knowledge and experience and personal touch at PYE 365. So check it out. There's a lot of educational tools on there to learn a little bit more, to see if it applies to you, and I think it's a great deal.
Yeah, and we have, all of the sites you can take a look at them that Rick did is bottledbusinessshow.com, PYE 365, WFB Legal Consulting. There's a few others. I had an old newsletter I used to do, and that was at Bottled Business Sense, without the word show, bottledbusinesssense.com. So anyway, there's a lot of different stuff out there that's free material, whether you're on the website or the show site. You can really go back and look at old videos. You can download them, like I said, to iPod. You can get a massive education in the field of law and in the field of general business if you choose to spend some time doing this. Now, remember, all of these are general principles that will have to be adapted to your specific situation. So these are not engraved in stone, meaning that you can take them to the bank and they'll apply to you. They're general principles that you then have to take once you have knowledge of them and have them applied to your situation to see how that particular principle affects your specific situation. And it may require you to have an attorney, more than likely, and I would suggest you do. Have an attorney in order to ensure that happens correctly, and a CPA as well on some of the issues. And of course, you'll see some older videos there where Rick does some marketing things, and we've always recommended you have a marketing consultant, attorney, and CPA. And of course, in that order, I would rank attorney first, CPA second, a marketing consultant third. And maybe I'm prejudiced, but that's the way it is.
Well, thanks again, Bill. This is an excellent episode. Folks, you can always look back at our previous episodes at bottledbusinessshow.com or reach out to us on Facebook, Twitter, LinkedIn, subscribe to us on YouTube, and of course, if it's easier for you on the go, subscribe to us on iTunes, and the library is building on there, so there's a ton of new content on there. There's some valuable content that we've talked about and Bill has talked about in the past. So check it out and subscribe to our channel.
Yes, and go and enjoy yourself. I mean, I think of these as learning experiences when I listen to different podcasts. And remember, I hate to keep saying this, but it's true. This is free stuff. It doesn't take much to think to yourself and say, "Hey, this is for free. Why would I not want to take advantage of it?" The more educated you are, I think the better off you're going to be. So take advantage of it. And in the meantime, we'll see you next time with a new show. And remember that we do things for 3 areas of law: the business asset protection area, the estate planning area, and of course the employment area. That's the model that we use. And we'll look forward to seeing you next time with a new episode, right?
Absolutely. We'll see you, folks.
Okay.
Thanks for joining us, and we'll see you again in the next episode of the Bottle Business Sense Show.
Take care, everybody.